Hi, I'm Stephen Gasquet with the National Association of Realtors. Thank you for joining our webcast, The New Closing Rules, from the NAR studios here in Washington. Today, we'll be talking about big changes to the forms and the process that lenders will have to go through when your clients buy a home. The changes take effect soon, and they come from a new set of federal rules. Today, we'll have a national expert on the closing rules, along with an NAR senior counsel right here to tell us all what to expect. And if you have questions about those rules, get ready, because you'll be able to ask them later in the webcast. We'll put instructions up on your screen. But first, let's begin today with a short video about those new federal rules and the changes you will see at every real estate closing in the future. Changes that have a lot of realtors asking a lot of questions.
What happens if the new regulations cause a delay in the closing and the rate lock expires?
What should we be asking the settlement entity and the lenders about their preparation for dealing with the new legislation?
With the new regulations, will the agents need to change the way they structure the contract?
Two complex federal laws govern residential real estate sales and mortgages in America. One of those statutes, the Real Estate Settlement Procedures Act, known as RESPA, requires the disclosure to buyers and sellers of all the costs involved with a home transaction. The other, the Truth in Lending Act, TILA, lays out the information lenders must provide consumers when they shop for a mortgage. Those overlapping laws have long been a source of confusion for consumers and frustration for lenders. So, when Congress passed the Dodd-Frank Wall Street Reform Act in the wake of the financial crisis, it directed the new Consumer Financial Protection Bureau to simplify matters and bring RESPA and TILA together. The merger of the two laws means the closing documents and timelines you're used to will go away. Gone will be the familiar good faith estimate and HUD-1 forms. In their place, the new loan estimate and closing disclosure. The new forms come with strict new requirements for lenders and a higher risk of delays at closing time. Lenders will have to tell consumers how much a loan will cost within 3 business days of a mortgage application. And mortgage providers will need to give borrowers more precise figures than they are required to provide now. Perhaps the biggest change for real estate professionals is that last-minute changes at the settlement table will be more difficult and in some cases impossible. This is because the CFPB will require the buyer to know 3 days in advance precisely how much the transaction will cost. So, if you spot anything during a final walkthrough that alters a sale in any way and the closing form is changed, that change will require lender approval. The CFPB's goal with these changes is to make the home buying process better for consumers. But everyone involved in the transaction will have to work together very closely to ensure no one goes home disappointed instead. And we are back now live in the NAR studios in Washington, D.C. And as promised, we have two experts with us on the new closing rules. First of all, Phil Schulman, a partner with K&L Gates. Phil, welcome.
Well, thank you, Stephen.
Phil is one of the nation's top experts on federal consumer finance laws, including the Real Estate Settlement and Procedures Act, commonly known as RESPA. And he's a former official with the U.S. Department of Housing and Urban Development. Phil, again, thanks for being here today.
My pleasure.
And also Finley Maxson, Senior Counsel at the National Association of Realtors. Finley, welcome.
Well, thank you, Stephen.
Finley is NAR's legal point person on the closing changes. He's also involved in many legal areas at NAR. You may have seen Finley on NAR's video series, Window to the Law. He's been at NAR since 1999. Finley, again, thanks for being here.
Thank you. No problem.
And as I said before, everyone watching right now can ask questions today. If you have a question, just write an email to the address that's about to appear on your screen. It is Realtor Mag Webcasts, that's plural, Realtor Mag Webcasts at gmail.com. And we'll try to answer as many of those questions as we can. Well, let's get to it. Gentlemen, let's walk through a deal step by step, showing our viewers exactly what's going to happen once the new closing rules are in effect. Now, the process starts when a home buyer gets the loan estimate. Phil, how does this new loan estimate differ from the current forms, and at what point in the process does the home buyer receive that form?
Sure. Well, currently, you get an initial TIL, which provides the consumer with an annual percentage rate and finance charges and allows them to comparison shop for a mortgage. At the same time, they'll also receive a good faith estimate, which will provide them with the lender's charges and other vendor fees. Those two forms now are merged into a loan estimate, and the loan estimate now will tell consumers what their mortgage payment will be throughout the 30-year life or 15-year life of the loan. And in addition to that, one piece of information that is missing from the new forms is how much money do I bring to the closing table. The LE on page 1 will do that. Now, you asked about when do you receive it. You'll receive it 3 business days after application. And what the CFPB has done in this new rule is to level the playing field. Presently, each lender defines what constitutes an application. So you might bring 7 pieces of information to one lender and get a good faith estimate, bring the same 7 pieces to another lender and not receive it. Under the new rules, everybody operates with the same 6 elements, and the CFPB feels by doing that, you'll get this form into the hands of the consumer sooner.
Well, that sounds good. Now, Finley, it seems at this point the ball is in the lender's court. What information is important for the real estate professionals watching this to know?
Well, under this rule, real estate professionals actually have no duties, but they are the ones who are going to be the people to explain the new forms to consumers. So at this point, once a consumer receives a loan estimate, if the real estate professional knows that the consumer wants a quick transaction, they can encourage the consumer to respond quickly to the lender and evidence an intent to proceed with the transaction. Under the rule, consumers have 10 business days within which to decide whether or not they're going to go forward with the loan. But the faster they get back to the lender, the sooner the appraisal and all the other things that the lender needs to do to get the loan transaction on track.
And like so many things in a transaction, the realtor is there to help them hit the deadlines.
Correct, right.
Good. Thank you, Finley. Now, next, Phil, the loan estimate spells out every penny the buyer will have to pay when they get that mortgage. Are those numbers just estimates, or are they the actual prices the home buyer will have to pay?
Well, a little bit of both, as always seems to be the answer on these things. In many ways, the CFPB has taken the estimate out of the good faith estimate and has tried to get the lender to put on the form the actual prices. And they've created 3 buckets for each of the various vendor fees that are used in a mortgage. So, for example, the first bucket is the zero tolerance or no variation bucket. These are the lender's own charges for origination, processing, underwriting, discount points. Whatever fee the lender puts on that form, the customer must be charged that fee. If it increases by even $1, the consumer is entitled to a full refund. The second bucket is the 10% bucket. So there are services that borrowers can shop for, and we'll talk about that a little bit later, I'm sure. If the consumer uses those services and the aggregate of those services increases by more than 10%, then the consumer again is entitled to a dollar-for-dollar refund. And the third bucket is called the variations permitted bucket. There, a lender couldn't possibly know, for example, what the property insurance costs are going to be or what the homeowner association fees are. So there the lender can put an estimate on the form, and if he's wrong, there are no penalties. So the answer, quite briefly, is some of the charges are solid, others are not, most are solid.
Okay, so the buyer gets the loan estimate, and then their credit tanks. Their credit score just plummets, or the property doesn't appraise. What happens then?
Well, there are changed circumstances, and that's what you're describing. As I just mentioned, lenders are very concerned that that loan estimate be accurate, because if it's not, they have to give refunds. But if something happens that is beyond the lender's control, the lender has certain flexibility to provide a new loan estimate. And I'll give you a couple of examples. One, If the borrower says, you know what, I don't want an adjustable rate mortgage, I think I'll have a fixed rate mortgage. Well, that's going to require all new figures, so a new loan estimate is given. The borrower says, I'm going to let my rate float. I think the rates are going to come down. And once the borrower locks in, well, of course, you're going to have entirely new figures. So again, a new LE. So while most of those figures are locked in, and most of the time it won't change, there are circumstances, again, beyond the control of the lender, where he will be allowed to issue a new LE.
Interesting. And Finley, again, in this stage, what role does a realtor play?
Well, this is exactly, kind of, it's very similar to the last question you asked. Here, what the real estate professional can do is make sure that both the buyer and seller understand that if there is one of these changes in circumstances, that's communicated to the lender as quickly as possible to keep the transaction on track. So, if a tree falls on the house, that should be identified right away, because that's obviously going to have an effect on the value of the property. Or if, the borrower loses their job or has some other impact to their income, that should be communicated immediately to the lender if they want to keep the transaction on track.
Good. And again, you can write us email questions at RealtorMagWebcasts, that's webcasts plural, at gmail.com. RealtorMagWebcasts at gmail.com. Gentlemen, let's talk about referrals. Does the lender make suggestions on where the home buyer can shop, or can the lender actually require the home buyer to use certain vendors?
Well, I'll take that one. I think the answer is both again. The lender may require the use of certain vendors. For example, an appraiser. A lender is not going to permit a home buyer to use his brother-in-law to figure out whether the house is worth $500,000 or not. So if it's an appraisal or a credit report or a flood certification, the lender selects the vendor and the borrower has no alternative but to use that. But the other vendors, title insurance, closing agent, closing attorney, homeowner's insurance, home warranty, the consumer may shop. The lender is obligated to put together a list, and the consumer can either choose from that list, or perhaps the real estate agent will make a suggestion and they'll go there. So the answer is some of the fees that they have to pay and some of the vendors they have to use, they don't have a choice in, but most they can shop.
I see. And Finley, how about the way this information is presented on these new forms?
The forms are a little different than real estate agents are used to right now. The costs for the transaction are very clearly laid out and listed, and the forms are actually consistent from the loan estimate to the closing disclosure. So they are a little different. The CFPB is actually going to create a website for real estate professionals to help them become familiar with the forms, so that if they get questions from their clients, they'll be able to educate their clients on these new forms.
That sounds good. Thank you, Finley. Let's fast forward now to the week of closing itself. We're in the final stretch, and our attention turns to the closing disclosure. Phil, what are the big changes we will see in the closing disclosure?
All right. Well, I think the very first change is a change in philosophy. HUD was in charge of the HUD 1 settlement statement, and their view was to bundle all of the charges. And I'll give you an example. Suppose you were going shopping for groceries. You need milk, eggs, cheese, butter, and cereal. HUD's view was just tell the consumer how much the bag of groceries cost. It cost $132. Now you can compare $132 to $162 for the same set of goods. The CFPB's view is to unbundle those charges. So they are requiring you to put out the price for the milk, for the eggs, the cheese, and the butter. It's a difference in philosophy. The new forms are what is referred to as dynamic. That is, they may change. No two forms may be exactly alike because, for instance, a borrower may not get a home warranty. They may not get a certain tax policy. And so the form lists the services in alphabetical order, and it may not be the same for every consumer. So that is a real challenge, for example, for the software providers who are trying to create programs to put this stuff on paper. I want to take a minute to tell you about the new form because it's 5 pages. Not 3, but it's 5 pages, and it's chock full of information about the loan terms and the fees that you will pay. The first page tells the consumer this is how much your mortgage payment will be at various points during the life of the loan. And as I said before, like the LE, it tells the consumer how much they need to bring to the closing table. The second page will list all of the services, and for the real estate agents out there, it looks very much like the second page of the HUD-1, other than it doesn't have specific numbered series because it only lists the items in alphabetical order.
Okay.
They also put out a comparison of the LE charges to the final charges so consumers can figure out whether they can get a refund. The fourth page tells the borrower information about whether he'll get to keep his appraisal, whether the lender is going to do his own servicing or sell the servicing. And the final page is the contacts page, and it will list who the real estate agent is and how you can get in touch with him or her, who the lender is and who the title agent is, because I think probably in 3 or 4 years after the transaction closes, they just can't remember that name. They'll have it all there. So the form has chock full of information. We were talking before the show started about the fact that it is easier to understand. The question is whether consumers will take the time to read 5 pages. We'll have to see.
Law students will.
Law students have.
Every settlement I ever went to that had a law student as a client, boy, they read every single paragraph. That's a good thing. Now, the borrower must receive the closing disclosure 3 business days before the closing happens. Phil, let's talk about that deadline. Everybody in the country is talking about the 3 days. What's it mean and why is it important?
Okay. Well, it's probably the most significant change because presently, as many of our audience know, that HUD-1 form sometimes doesn't get prepared until 15 minutes before closing. Now it must be in the hands of the consumer 3 business days before closing. So how are you going to get it there? There are a couple of ways. One, I suppose the lender could hand deliver it to the home buyer, but that would be expensive. Second, you could send it Federal Express, but what if you send it to an apartment building and the manager signs for it? How do you know the consumer got it? You could send it electronically, but consumers then have to get what's called e-sign notice, and there are a whole bunch of federal laws involving that. So most lenders will follow what we call in the law the mailbox rule. So the mailbox rule presumes that 3 days after you put a package in the mail, the addressee will receive it. So let's take the following example. May 22nd is a Thursday, and that's when you want to close. If you're going to mail it, you have to put it in the mail on Thursday the 15th, a week ahead of time. If you mail it on Thursday, Friday, Saturday, we don't count Sunday, the consumer is presumed to have received it on Monday. That's 3 days before Tuesday, Wednesday, Thursday. If you have to put that form in the mail 7 days before closing, you've got to have all those figures ahead of time. Mm-hmm. And it's likely that there'll be changes at the last minute, and I'm sure we'll talk about that. Consumers should not be surprised, nor real estate agents, if there are 2 and maybe even 3 closing disclosures. But there are severe penalties for the lender if he doesn't deliver on time.
Interesting. And again, Finley, what role does the real estate professional play here?
Well, I mean, just like Phil said, you know, the lender is going to want to have the numbers pretty solid a week ahead of time in order to issue the closing disclosure. So what we're recommending is that real estate professionals help their clients understand that negotiations, you know, should be completed as soon as possible between the parties. They shouldn't wait to the closing table to spring a surprise on the other party, because that could affect the whole transaction.
You know, there's some misinformation going on right now that a lot of people are saying any change and the 3-day clock has to start all over again. That's not necessarily true, is it, Phil?
No, it is not necessarily true. And I think there's been a lot of hysteria over this fact that, my goodness, if there's going to be a change of $5, they're going to have to do a new closing disclosure and we're going to have to wait 3 days. The answer is this. First, take a deep breath, relax. In almost all cases, the CD can be corrected at the closing table or even after, within 30 days. There are 3 areas, however, where if that change occurs, you must stop the proceeding and wait an additional 3 days. One is if the interest rate on a purchase money mortgage fixed rate goes up by 1/8%, or a variable rate, an adjustable rate, goes up by 1/4%. If it does, between the time the CD was issued and you go to the closing table, stop the closing, must wait 3 days. That's probably not going to happen. The second is if the consumer says, again, I changed my mind, I'd rather get a fixed rate rather than an adjustable rate. Stop the proceedings, again, a new CD, and wait 3 days. Or finally, if an investor says to a lender, I want a prepayment penalty in that note in case the borrower pays off early, again, stop the proceedings and let's wait 3 days. But other than those 3 reasons, the closing will proceed and the corrections will be made either before closing or within 30 to 60 days. So, again, breathe easy.
Phil, thanks. Now, Finley, before we get to our viewer questions, one last thought. What's the most important takeaway for the real estate agents and brokers and associations who are watching this right now?
Well, so we have sort of 3 things we've been trying to emphasize. So the first is we've talked about during this broadcast, there's a lot of new timing requirements in these rules. And it seems like, it's certainly in the beginning, these transactions are probably going to take longer than they do right now. So what we're recommending is that if transactions take 30 days in your jurisdiction right now, you should add 2 weeks. And correspondingly, if it's 45 days, then you should add so it should be close to 60 days. So that's the first thing. The second thing, because there is the possibility of a delay in the closing in the beginning, you may want to steer your clients away from doing back-to-back closings, because there's a possibility that one of them could be delayed and they may not be able to either complete their sale to buy, or vice versa, they may not be able to move into their new house.
Well, that's pretty common, where someone will both be selling a place and buying another place. They'll close on the sale in the morning, then purchase in the afternoon. You say that's risky?
That is, at least in the beginning, that probably they should try to steer their clients away from doing that, at least in the beginning.
Good.
Well, one of the other challenges there is, of course, if you have 2 different closing agents, the second closing agent may not get all of the figures and has to provide that 3 days before closing to the seller, who's now going to become a buyer.
Right.
So if you are going to try a simultaneous closing, probably need the same closing agent for both. It would be easier that way.
Maybe let everything settle down a while before you try a coinciding settlement?
I think so.
Yeah.
And so we had one other takeaway, and we already talked about it. The negotiations. You want to have the negotiations between the parties completed as soon as possible, because, like Phil said, the lenders are going to be sending out the closing disclosure a week ahead of time, and so if there are last-minute changes, that could derail the whole process.
So just one more thought here. What about the final walkthrough? Can that still be an hour before closing, or should it be pushed way back earlier in the week?
Well, I would say the prudent thing to do would be to try and have the walkthrough maybe 3 or 4 days before closing. But I know, in talking to many real estate agents, that's not going to work, because now the homeowner has moved the couch and we can see the stain from the wine, and that doesn't happen until the morning of. So I do think we should try to schedule the walkthrough 3 or 4 days earlier, maybe with another one at the day of closing. But as Finley said, you want to keep changes to a minimum, because you're going to have to go back to the lender to get an approval for any change that you make, and that can delay the closing.
That's a really good point. Really good point. Well, gentlemen, are you ready for some questions from our viewers?
Sure.
Good. Again, we're going to take your questions now. And if you have a question for our gentlemen on the panel, please direct those questions to realtormagwebcasts@gmail.com. And again, webcast is plural, so realtormagwebcasts@gmail.com. Now let's start with a question here. We've been told that the closing documents are going to be prepared by the lender instead of a local settlement attorney, which means we may be relying on someone on the other side of the country to prepare those documents. Is that true, and how might that affect settlement? Phil?
Yeah, well, there is a big change, because lenders have full liability now for what's on that closing disclosure. And so if they're going to have liability, they want to make sure that it's prepared properly and that it's delivered within 3 business days of closing. Because of that, they're going to prepare the form, not the title agent. So it's very possible that the lender will prepare that form and send it in the mail from a central location that's halfway around the country and not where the property is located or the real estate agent is located. But again, because it's going to go through the mail or it's going to be an e-sign through the internet, it doesn't really much matter. Real estate agents aren't going to have the same contact with the preparer that they do in the case of a home buyer. With respect to the seller, though, closing agents will still prepare the CD for the seller. So if you want to get a copy or you want to know what's going on with respect to the seller, that will be easier to do. The home buyer, as the question suggests, may be dealing with a lender halfway around the country.
And here's kind of an obvious question, but let's put it out there. All cash sales, none of this applies.
All cash sales, none of this applies. So go find borrowers who've got plenty of money and you won't have a problem.
Well, you know, as we prepare contracts, as realtors prepare contracts, can they no longer rely on a 30 to 45 day settlement, or should they be building in more time, 45 to 60 days, for example? Finley, you want to take this one?
Yeah, I mean, that's just kind of what we just touched on. You know, we're recommending something like planning on the transaction to take 2 weeks longer than it normally does. So I know the timings vary across the country, so whatever a normal transaction is in your jurisdiction, you should add 2 weeks, at least in the beginning of these rules, because, you know, we're expecting transactions to take longer due to all the new disclosures and everything that need to be made.
You know, typically in most markets, the buyer picks a settlement company. Is that still legit? Is that still okay?
Well, sure, because the transaction still has to be closed and the money dispersed, so they're still going to pick a closing agent, but where before the closing agent was preparing the HUD-1, now the lender will prepare it.
I see. We're still reading questions from our viewers here. Now, how do you foresee the use of pre- and post-settlement occupancy agreements to deal with the potential delays in settlement? That's a good one.
Well, I think that if the process is going to be delayed another 15 days, you're probably going to have some rent-back situations, and so we may see an increase in that. But for the most part, it should be very similar to, I think, what we experience now. But again, if there are going to be delays and the seller absolutely has to be out of there, we may get some rent-back situations, more so than we have presently.
Okay. Again, if you would like to send us a question, please address it to realtormagwebcasts@gmail.com. Now, here's another one that I hadn't thought about yet. Do all the rules also apply to commercial sales?
So no, I mean, these rules apply to residential transactions, you know, where a consumer is taking a federally insured mortgage and is going to occupy the property. That's when, you know, both of these rules would apply. So no, it does not apply to commercial sales.
Right, so that's a couple of important points that our members should know right off the bat. No commercial involvement and no all-cash sales. Those are both completely separate from these new rules.
I just noticed half the audience just left.
Well, investors too. So someone
Right.
investing in the property, you know, not to live there, but just to be.
Right, but anyone who's buying a property with a mortgage, like if it's a second home, that's all still
That's still
part
covered.
of this.
Yep.
Okay, good. Good. Okay. What if the purchase price changes or if there is a financial concession due to an inspection result? What happens then?
Well, again, unless it's one of the three items that I mentioned, the increase in the interest rate, changing the type of loan, or putting a prepayment penalty in, you will have an opportunity to modify the CD either before closing or, in the example you gave, since it's a numeric change, to do it within 30 days. So you have time to clean it up and still go forward with the transaction.
You know, when many realtors put together a contract, there's the what if clause. Contracts include a lot of demands. You must do this, you must do this, you must do this. But sometimes they don't have the what if clause. What happens if you don't? What happens if that 3-day timeline is not hit or any of the other rules are broken here?
Well, that's the number one question that my clients always ask. What's going to happen to me if I screw this thing up? Well, again, as Finley pointed out, with respect to real estate agents, primary liability does not rest with you, it rests with the lender. And under the rules, if the lender does not hit these time frames, they can be sued for actual damages, penalties of up to $4,000 per transaction, plus attorney's fees. That's why it's so critical. Now, if it's a single transaction, that's not going to be a big deal. But what if the lender has done the same thing in 4,000 transactions? Now it gets to be pretty expensive, and the class action bar is just sitting out there waiting for mistakes to happen. In that regard, the NAR has been asking the CFPB to give a grace period, to say
Right.
to say to the industry, if we're doing a good faith effort in trying to comply, don't whack us with penalties. And the CFPB, as recently as this week, Director Caudray spoke testified before Congress and said, we will go out and do our reviews, but if we find that there are some errors, we're going to try to help the lenders to get those errors corrected and try to avoid penalties at least the first few months. So I think there'll be this shakeout period between October 3rd, when the rule becomes effective, and December 31st, where everybody's going to get an opportunity to do their best, but understood that mistakes may occur.
Thanks, guys. And one more question coming in from our viewers. What should we be asking the settlement entity and the lenders about their preparation for dealing with the new legislation? For instance, should a realtor say to a settlement company, are you ready? What do you think?
Well, I mean, it's going to vary. There's going to be, the lender who's going to be in charge of the transaction, but they're going to have a closing agent who's going to be the one, and that's going to vary across the country. They're going to be the ones who are actually going to be doing the closings. So, that is who, more than likely, the real estate professionals are going to have contact with. So, yeah, we definitely think it's a good idea for the member and possibly the realtor associations in each jurisdiction to become familiar with how these rules are going to be implemented in their jurisdiction and what changes it will make to the traditional way transactions are closed.
I was going to make a comment that, all real estate agents have a favorite lender or a favorite closing agent that they like to deal with, and I'm not suggesting you shouldn't, but during this period, there's going to be new software introduced, and a lot of electronics are going to be involved, and some lenders and some title agents are going to collaborate and coordinate, and this thing is going to run smoothly, and others not so smoothly. I think real estate agents would be wise to talk to their colleagues about who's getting this stuff done quickly and avoiding delays, and maybe that's where you ought to be looking for business during this temporary 3 or 4 month ramp-up period.
That's a very good idea, yeah. More questions coming in. Are there any changes to NAR suggestions for how brokerage compensation and fees should be handled with the new closing procedures? Should they be communicated to the closing attorneys or title companies? For example, commission, cooperative commissions, rebates, referral fees, etc.
No, I mean, commissions should be determined by the individual real estate companies. NAR has no recommendations on commission structures, and frankly, these rules shouldn't have any effect on that.
I would agree with that.
Would you? Good. Now, how about this question coming in? If the lender is preparing the closing documents, what will the closing agent's responsibility be? Just to be the sort of the traffic cop?
Well, no. The closing agent will have a lot of responsibility. Number one, all of the documents have to be signed and notarized. So the note, the deed of trust, the mortgage, and so forth all have to be signed. The money will come in, and of course the closing agent has to disperse it to the prior lender, to the recording, to the local county officials, and so on and so forth. So plenty to do for the for the title agent or closing agent. The only thing that's going to differ is that closing document now is going to be prepared by the lender rather than the title agent. And even then, some small lenders, maybe community banks, credit unions, may not have the sophistication to prepare these forms or have the software, so they may still look to the title agent or closing agent to prepare them. So plenty to do for the closing agent, still an important function.
Okay. And again, for our members who are watching this, we know that the laws are directed at lenders. The laws are directed at people, at transactions that involve mortgages, that involve residences, as you just said. There are a lot of transactions that could still transpire without any involvement at all of these new closing rules. Can we go through that one more time and tell our members which ones they don't have to even worry about because they're going to be done the same way next year as they are now?
Well, for example, reverse mortgages are not covered by this rule. Investment properties would not be covered by this rule.
As you said, all cash.
All cash would not be covered by this rule. Lenders who make less than 5 loans a year would not be subject to this rule. But generally, if there's going to be a lien on the property and it's going to be for the purchase of a 1 to 4 family residential structure, then the rules are going to apply.
Okay, here's a question. I am, for instance, a property owner. I own 20 condos and I'm older now and I decide I'm going to sell them all. I don't have any mortgages, but my stipulation is I'm going to hold the notes on every one of the places that I sell. I'm going to become the bank. Do I have to comply with these new rules?
Well, first of all, you're going to make 20 sales to 20 homeowners who are going to get mortgages, so the rules are going to apply there. However, if you're a creditor in that situation, I believe if you give more than 5 loans to owners, you will be subject to the rules.
Okay, good.
Less than 5, no.
Because it sounds old-fashioned, but as we know, seller-held financing is still a big part of the real estate market.
Absolutely.
Good. And Finley, any thoughts on the other preparations that our members should know about as far as what is not covered?
Well, I think, they just commercial properties, a lot of the things Phil's mentioned them all. I mean, one thing I'd like to recommend to all the viewers would be, to look at the new forms. The CFPB, has all the forms on their website, and like I said earlier, they are going to at some point going to have a website which is designed to help real estate professionals understand the new forms. So that is something we really recommend all the members go out and take a look at these before they're implemented on October 3rd.
We know great minds, because we just got a question saying, how can we review the new forms? Maybe we could elaborate a little bit about where people can find them and what they'll see when they go there.
Well, they can go to the CFPB's website, and then they have a tab that says forms, and you can go there, and then they have different variations on the forms for different types of transactions, and they also have completed forms, so you can kind of see what one would look like when it's used in a transaction. It lists out the charges. They have this, what Phil mentioned, they have also an example of what a seller would receive, so you can also see that, even though that is going to be prepared by the closing agent. There is an example of one of those forms there as well.
That brings up a very good point, but Finley's right. CFP.gov, you can get copies of the forms, but your lenders are there because they understand that they need to earn your trust and faith, and it would not be inappropriate for you to say to the lenders you deal with, these forms are going to be out in a couple of weeks. I'm not even sure what they look like. Can you sit down with me, or are you offering any educational classes to help me in that regard? And I think lenders would be more than happy to make sure that you understand what's going on.
Nice, nice. And I want to thank our viewers for sending in such awesome questions. They're pouring in, and we invite you to join them at the email address that, can we put that up on the screen, please? The email address to write our questions to is realtormagwebcasts, plural, @gmail.com. So some of the latest ones, please.
Can I make a comment
Yes,
that I think would be helpful? Heard a lot from our real estate agent clients saying, I'm told that there's confidential information on these forms, and I'm not maybe going to get to look at it, and I need to see that in order to counsel my client. Well, it's true that in the home buyer's closing disclosure, there will be confidential information about his or her loan, which he or she may not want the seller to see. So it's very likely that there'll be 2 CDs created, one closing disclosure for the home buyer and another for the seller. If the real estate agent wants to see those forms, they should speak to their client and ask the client to sign a release or a waiver to tell the lender to make it available to them. Some real estate brokerage firms are creating their own release, having the consumer sign it and giving it to the lender saying, please share this with the real estate agent. So if you feel that you need copies of these things, get the client to give permission. Mostly the home buyer, because the seller will have their form prepared by the closing agent, and there you're likely to get a copy. But the home buyer's copy, need to get a waiver from the consumer, and that should be easy enough to do.
And I know realtors, there are some realtor associations we've heard who are also creating these forms, and they're going to be part of the standard form contracts that will be used in the transaction.
So the realtor should just hold on, and the forms will be adjusted and provided to them by whoever they get their forms from now.
Well, maybe. I mean, we don't know if they're going to have that particular part, but yes, that's something we're recommending, is that if associations do create these form contracts, that they should take, they should lay out the timelines set forth in those contracts, and then compare with these new disclosure rules and see, do they match up, and do changes need to be made. Like one change that needs to be made is if there is one of these delays. Right now, if the buyer can't close due to one of these delays, the buyer would be in breach of the contract. So there's something right there that needs to be fixed. Another thing is a lot of them require an immediate ordering of the appraisal, or soon after acceptance. Now, because there's this 10-day, the 10 days where the buyer has just to decide whether to proceed with the transaction, that also could drag out the ordering of the appraisal.
When I was at NAR's mid-year meetings in May, a realtor came up to me and said, "There's not a thing in here about sellers." True?
Well, I think the CFPB forgot about sellers. It is true that these forms are created, and these disclosures are created for the home buyer. Very little about the seller is provided in these forms. So the closing disclosures will still be created by the title agent or the title attorney, and it almost seems as if sellers have been lost in the process, which may be a good thing for them. But clearly, the focus is on home buyers on these rules.
So a lot of people watching right now might be listing agents who just do the selling side of the transaction. Can they just relax?
Well, the forms are still going to be used. They're going to get the new forms, the new LE and the new closing disclosure. So no, they shouldn't relax.
Right.
They need to be up to date on it, but it's just that they will have easier access to the forms, and there aren't as many rules and I's to dot and T's to cross if you're a seller. So it'll be a little bit easier.
So if you're a listing agent, don't relax yet.
It'll be like the things like we mentioned before, so if there is some change in circumstance, which will cause a new loan estimate to be issued. So like if something happens on the property, that could change the property's value, that is something, the listing broker should get that out there as soon as possible if they want the transaction to go forward.
And just to drill down a little further, if I am a home seller, then I will still be seeing the new forms and they'll be part of the transaction, but again, I'm not going to play an active role in the new closing disclosure rules.
The disclosures and costs are for the benefit of the home buyer, not the seller, but the seller will receive a form as well.
Good. We've got some more questions coming in now. How will this is a great question, how will these rules affect the purchase of a bank foreclosure, or will they affect short sales as well?
Well, if it is an REO and the purchaser is going to get a mortgage, then the rules would apply. If the purchaser of the REO is going to pay all cash or is going to be an investor, then RESPA and some of these rules would not apply. So it depends on who's buying and what price or how they're paying for the new property.
Okay. And obviously in today's real estate market, electronic communication is a big part of it.
Critical.
And that's what this new question is all about. Am I understanding that the closing disclosure can only be mailed to a buyer or hand-delivered, or is e-sign an option, for instance, DocuSign? What happens if a buyer doesn't receive within the 3-day mail day period? Now, I think we may have answered that one already, but again, let's take it from the beginning. Can we use email? Can we use DocuSign?
You can use email, but there are e-sign rules that the consumer has to get an e-sign notice, has to acknowledge that they have the capability to get things through the internet and to sign for it. But e-sign is permissible, and electronic certainly will be used, but there are a couple of extra steps that have to be taken in order to do that.
And the mailbox rule still even applies to emails. There's still that presumption of the 3 days. So.
Well, yes, but of course with an email, if you can get a read receipt on it, then you know for sure that the consumer, at least at that email address, received it.
So we're
that's
pushing
pretty good
into
proof.
Pushing into the future of electronic communication. We're not going back to all paper again.
No, we're not.
Good.
We're not.
Good. Another question. Contracts vary from state to state, but most financing contingencies have an automatic extension of 3 to 7 days should it be the lender's fault for the delay. Will a change in the HUD fall into that time frame and therefore be automatically extended, or would the contract need to be extended with an amendment to protect the buyer?
Well, I think, the contract, these contracts vary a lot by state. And so, like I said before, well, the question said, reference the HUD. Now, once again, we'll say the HUD one is not going to exist any longer for these types of transactions. So, what they need to, what the people who create these forms, which in a lot of cases are state realtor associations, they need to put provisions in first for keeping, so the buyer will not be held in breach if the delay is through the rules, not a lender delay necessarily, but through the rules. But they also should take into account a possibility for lender delays, because that is another possible delay. So they just need to look at all the timelines in these rules and adjust their contracts accordingly.
I think that's why we think it's going to probably take an extra 15
Right,
days
exactly,
at
right.
the beginning.
Yeah, exactly, right, yeah.
But again, I think over time, everybody will get the hang of it, and the 15 days will shrink maybe to 10 days or 5 days, and maybe only a few days once everybody understands the new rules.
And in case anyone has joined us in progress, there's a really important point I'd like to stress, and that's that 3-day extension. If they don't get the closing disclosure in time, everyone across the country who does real estate is afraid, as you said, that if there's a $5 discrepancy somewhere, the whole thing has to wait 3 more days. Can we look at that one more time and sort of give our members some clarity there?
Sure. I think that there has been some hysteria over this idea that the CD, the closing disclosure, must be in the hands of the consumer 3 days ahead of time. And if there's any change, you have to do a new CD and the 3-day clock starts running again. Not true. The 3-day clock only starts running if the interest rate increases by more than 1/8 of a point on a fixed rate mortgage or 1/4 of a point on an adjustable. It only delays closing if the consumer decides he wants a different type of loan, perhaps a graduated mortgage, an adjustable rate instead of a fixed, or if there's a pre-penalty. If none of those 3 things happen, we can correct the CD at the table or within the next 30 days. So I think, at least with respect to that, Stephen, it'll be business as usual.
Here's a big question. Do you see that 3-day delay as killing any deals?
I'm going to let Finley answer that question.
It would depend. The way it would kill a deal would be, if they're doing the walkthrough and they find some catastrophic problem with the property and a new appraisal needs to be ordered, and the whole thing falls apart. That's the only time that But then potentially there could be a breach of contract. But that is when potentially that would happen. But that could happen now. That's not something that's different under these rules.
Right. As I was talking to Phil earlier, I said if someone misspelled my name and put a V instead of a PH, that doesn't start the 3-day clock.
No, it does not. And in fact, the rules provide for changes. If the change is numerical, having to do with money, it can be corrected within 30 days of closing and a new CD sent to both the seller and the buyer. If it's non-numeric, in the case of Stephen's spelling of his first name, he's apparently very touchy about that, the lender has 60 days to correct and get the new form to the consumer. So it's not going to result in a 3-day change.
Excellent. The questions continue to pour in. Is there any wording that should be added to purchase and sales agreements to offset or address closing delay problems?
We've surveyed, the realtor associations around the country to see how they are addressing this. And they've taken a lot of different approaches. And it's interesting, some states, they actually already had this flexibility built into these contracts. So we don't have a universal fix to this. This is something that's going to vary by jurisdiction, because the practices for closings vary so much. So this is something the associations need to work on with their forms committees and with their lawyers to figure out what the best way to handle this in their market is.
Stephen, if I may, let me point out another change that folks don't really think about. The rule is that the closing disclosure has to be in the hands of the consumer 3 business days before consummation. It doesn't say before closing. What does that mean? It means at the time the borrower signs the note and is obligated on the debt. Now, in most cases, I live in Maryland, we do a closing here in Maryland, we sign the note at the closing table. So the closing and the consummation occur on the same day. But in the West, very often where you have escrow closings, the consummation takes place first and then the closing takes place. So it's 3 days before consummation, not 3 days before closing. So if you're out there in California or Washington or Oregon or Arizona, then you may have a different time clock than we do on the East Coast.
We just got a really great question, and it is so direct and basic. I'd like to thank the person for writing it. And they said, I'm confused. Does this go into effect August 1st or October 3rd? It's a good question.
Well, first of all, thank you, Mom, for sending that excellent question in. Here's what happened. The final rule was actually finalized November 20th of 2013. And so we've had this final rule in place, at least know what it's about, since 2013. And the rule was that 20 months from then, August 1st of 2015, the rule would be implemented. However, the CFPB forgot, I guess, with all the rules they've written, they forgot to get these regulations to Congress 60 days before it became effective. And so they had to delay them. The rule will be delayed until October 3rd. So these rules take place October 3rd, no longer August 1st.
And the same person writes, also, help me with the acronym. What is CFPB? And I think, and they have a couple of others. So let's have a little bit of fun with this while we wrap up the show. First of all, CFPB.
Well, I have my own definition because I represent clients before that agency, but I will give you the official name, and that is the Consumer Financial Protection Bureau, CFPB. In fact, there was a bit of a tussle in D.C. because the FBI was not thrilled with the fact that the CFPB would also be called the Bureau. But ultimately, they prevailed. CFPB, Consumer Financial Protection Bureau.
Its people aren't agents, are they?
No, they are not. But they think they are, and I think if they could carry a gun, they might work for free.
Well, let's continue on that same very helpful vein. TILA, T-I-L-A.
Truth in Lending Act.
Right. RESPA, as we know.
RESPA has been the thing that has put my kids through college and allowed me to take vacation, so it's very dear to my heart. Real Estate Settlement Procedures Act, RESPA.
Then you put them together, and we hear the acronym TRID.
TRID. Well, TRID is dirt spelled backwards, but it stands for TILA RESPA Integrated Disclosure Forms, TRID, TILA RESPA Integrated Disclosure Forms, TRID.
You know, I think a lot of times in Washington we all assume that the acronym's got power, everyone understands it. So again, thank you for that question.
Well, there's one more too, just to make it a little more confusing. So the CFPB refers to this as know before you owe. So you might hear TRID from the lenders, but then the CFPB, they brand this as know before you owe.
You don't actually say NBYO, do they?
No, they do not have an acronym.
Good, good. Well, here's a really good question also. You know, a lot of settlements don't happen with both parties facing each other at the closing table. So how does this work if there is no sit-down closing?
Well, again, the form has to be in the hands of the home buyer 3 days before the home buyer signs the note, and the seller will get it typically the day before or the day of. But they don't necessarily have to be in the same room, just as today, under the use of the HUD-1, sometimes the buyer and seller are not in the same room. So that's not going to change, just the form will change.
Now here's a question about some state law, and this is interesting. This question comes from Oklahoma. The person writing says, in Oklahoma, we as realtors are required to provide good faith estimates to buyers. It seems like this is going to be complicated by the new rules. Should we lobby our state to repeal, or I would suggest, change that part of our law? What do you think?
Well, I would assume right now lenders have an obligation to get the good faith estimate into the hands of the consumer, and if the Oklahoma rule is still in effect today, then the two obviously are working in concert. I would think that probably that won't change. The real estate agents will continue to do their good faith form, and the lenders will hand out the LE. But hey, if you want to lobby your local legislators to get rid of it, more power to you.
And we're getting a lot of questions about different types of residences. So say in D.C. that you buy a condominium, you've got so many days to respond to the condominium documents after they're delivered to the buyers. And during that review period, the buyer can just kill the deal for whatever reason he finds objectionable in those condo docs. Will things like that, HOA documents, condo docs, will they come into play here?
They won't change. Those rules are still going to probably remain the same. Don't you think so?
Yeah, that stuff's, yeah, right, exactly. I mean, the only time, it may happen a little later than it does now because, nothing can really happen until the borrower decides to proceed with the transaction.
We've been glossing over that, but that is such an important point. The LE is in effect for 10 days. The lender is saying, I'm not going to keep these prices locked in forever. I'll give you 10 days, go shop. But if your consumer is in a hurry to close the deal, then real estate agents should be saying to their client, call up 3 or 4 lenders that afternoon, find the one that you want to go with, and give the intent to proceed to the lender, and we can cut 9 days out of the process. So that's at least one way to shorten those 15 extra days.
Another great question about a different type of residence. Say that there is a commercial farm that also has a residence on the property, which the buyer intends to occupy. I mean, that's sort of a hybrid question. What are your thoughts?
I think that they should live in the house and not the barn. But if they do live in the barn, then the rules probably won't apply because it's not a residential property. But the answer is the forms would apply to the sale of the house.
I see. In that case, if it is a commercial working farm and it has a residence on it, the entire parcel is usually commercial.
Well, then it would be a commercial transaction,
Yeah, right,
I think.
Right.
Yes, I think it depends on how the contract is structured.
Okay, so again, we're looking at October 3rd, but I understand that that's not absolutely set in stone right now, correct?
Well, the CFPB put out a proposed rule and asked the public if they were okay with October 3rd. I think that the public comment period is just ending. I will be shocked if anybody in America said, no, I want it August 1st. So
Okay.
I think it's a pretty good bet we can settle on October 3rd.
So if one of our realtors writes a contract and the closing is October 2nd, obviously the current rules apply. What if they write a contract and it doesn't go into closing until, say, the 4th?
Now that is an excellent question.
Right.
The answer is as follows. If the application occurred before August 3rd, then you would be giving out the good faith estimate. And if you give out the good faith estimate, you must use the HUD-1 form, even if it's new construction, and you may not close for 6 months. This is a challenge for lenders because they have to keep both the HUD-1 and the closing disclosure alive until those transactions end. But the answer is the new rules only go into effect if the application occurs on October 3rd. If it happens on the 2nd and they get the good faith estimate on the 2nd, you use the old forms no matter when you close.
Real quick, what if a lender wants to be proactive and starts using these forms on the 15th of September? Can he?
Cannot.
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 Good. Wow, this has been a great conversation. And gentlemen, that brings us to the end of our webcast. I'd like to thank everyone for sending in those excellent questions. Again now, Phil Shulman with K&L Gates. Any last thoughts for the thousands of real estate professionals watching this webcast?
Well, I told you to breathe easy, and I still would say that. There have been so many changes since the passage of the Dodd-Frank Act. Qualified mortgages, qualified residential mortgages, loan officer compensation, appraisal independence, TRID. We will get through this. We'll figure it out. It will become eventually old hat, and I suggest that by January 1st, we probably won't even remember what the old forms look like. So we'll live through it. Let's not get hysterical. We'll figure it out.
Thanks, Bill. And also Finley Maxson, Senior Counsel at the National Association of Realtors. To you also, what are your closing thoughts for our members?
Well, I think Phil said it very well. I mean, I think, the members should become familiar with these forms if they aren't already, and just be prepared when it takes effect and, keep their clients calm, but also set their expectations realistically so they understand, at least in the beginning, there may be some delays.
Gentlemen, thank you both for being here and for all the great information that you've provided to our viewers today. And thank you for joining us, and thank you also for sending those excellent questions to us on our special webcast, The New Closing Rules. We hope that what we've done today will help you keep every deal you do on track. I'm Stephen Gasquet with the National Association of Realtors. Thank you for joining us.